Hi everyone. Today I want to explain in simple terms how a foreign court decision can be recognized and enforced in Ukraine. So if you ever wondered whether a court decision from abroad can work here in Ukraine, let's go step by step. But at first, general rule, general legal basis. Each country is independent. No state can be automatically forced to recognize and to enforce another country's court decision. It might happen if there is a treaty or if both countries respect each other court decision through something called reciprocity. Legal basis in Ukraine. Similar in Ukraine, the foreign court decision can be recognized and enforced if there is a treaty or through something called reciprocity. But about this later. Treaty. For example, in September 2023, Ukraine joined the Hague Convention on Recognition and Enforcement of Foreign Court Decisions in civil and commercial matters. It means that from September 2023, to be exactly from October, between Ukraine and European Union, court decision must be recognized and enforced. If there is no treaty, for example, if there is no treaty, then in Ukraine, principle of reciprocity works by default unless proven otherwise. It means that if a foreign country respects Ukrainian court's decision, in its turn, Ukraine respect court's decision of this country, principle of reciprocity. A very good example is Germany. There is no obstacles between Ukraine and Germany in recognition and enforcement of court decision because both countries introduced this principle of reciprocity in their civil procedure code. Now, legal procedure deadline. You have 3 years from the day the court decision entered into force and became enforceable. Location. You submit your application to the civil court in the region, or to be exactly in the official location of the debtors or your contragent. If this place is unknown, so place of residence unknown, then we submit application to the civil courts at the place where the property of debtors or contragent is located. Documents. Along with the application, we submit a notarized copy of the decision we want to recognize. Also, we submit proof that this decision is already entered into the force and enforceable. Proof that the party was properly notified about the proceeding where this foreign decision was made. Also, if you act via lawyer, then we submit power of attorney and we submit translation of all above listed documents. Once Ukrainian court recognizes a foreign court decision, it issues an order. This order goes to the state enforcement service, and then it will be treated like a normal, usual local Ukrainian court decision and will be enforced in the general and the same procedure as considered for the Ukrainian court decisions. Enforcement is possible within the same 3-year period. For foreign judgments requiring periodic payments like alimony, you can apply anytime, but enforcement will only cover the last 3 years. Important note, there are exceptions. For example, if foreign court try to decide on something that Ukrainian legislation reserves only for Ukrainian courts, for example, disputes over real estate located in Ukraine, then in recognition will be refused. Let's go through the whole list of the grounds for refusal. According to the Civil Procedure Code of Ukraine and Ukrainian law on international private law, Ukrainian courts can refuse in recognition and enforcement of foreign judgments in 5 cases. We have 5 grounds for refusal. So, if public order conflict, if a foreign court's decision contradicts the fundamental principles of Ukrainian legislation, its constitution, its sovereignty, or public order, for example, such cases like foreign courts decides on the marriage under the 15 years, and they try to register this marriage in Ukraine, then no. Our legislation says that for marriage, minimum 18 years, and this foreign decision is against public order. Another example, foreign court sentences a Ukrainian businessman to pay damages to the government because he has criticized political leaders of this state. And in this state, such criticism is considered to be a crime. Ukraine looks at this decision and says, punishing someone for expressing his opinion is against public order. It is against human rights, human dignity, a core valuable standards of European human rights. Another ground, second, lack of due process. If the party against whom the foreign court decision was made was not properly notified about the proceeding or deprived an opportunity to defend, then this is a ground for refusal. Third, decision is not entered into force or is still subject to appeal. Fourth, parallel proceedings. If in Ukraine there is a court decision in the same case between same parties, or proceedings in Ukraine was pending before the foreign court started its proceeding. Another reason, another ground for refusal, if there is no treaty or no principle of reciprocity. As was already mentioned, if there is no treaty, then the principle of reciprocity works by default. But if there is no implemented principle of reciprocity or no treaty between countries, then this is a reason for refusal. So, in practice, the two most common grounds for refusal are procedural issues, not notified, not entered into force, still subject to appeal, and public order arguments. So, the court interprets it very, very narrowly, only for clear violations. To sum up, foreign court decision can be recognized and enforced in Ukraine either through treaty or through the principle of reciprocity. The process takes place in Ukrainian civil courts. It requires a set of documents and translations, and once recognized, the decision will be treated like a local one and will be enforced like a usual Ukrainian decision. That's it. If you want me to go deeper in some documents or real-life cases, please leave a comment, and I can record a separate video just on that. Till later, bye-bye.